storm coming very quickly. So I'm glad that all of you could attend this webinar. I'll just give you a little bit of insight about who I am. I am an attorney, like Kathy said. I work at a law firm called Fisher Phillips, and what we do is employment law. That's it. That's what we do. And I've been with the firm now for many years, and I have my roots as a teacher. I was a teacher for a long time, and then went to law school, and then now have been practicing employment law. I live in Carlsbad. I am a huge advocate of Carlsbad, and last year, I was doing this very talk in person with everyone. So this year is a bit different. And not only has this year been different for everybody, it's also been different in terms of the laws. We've all been, I'm sure, inundated with all the different changes with COVID, with OSHA, all of those issues that everybody's been trying to scramble with and trying to kind of understand and digest really quickly when everything else was sort of seemed to be falling down around them. So what I put together today, and I'll pull up the screen in a second, is a PowerPoint, which I'm happy to share with others if once you want to, if after this presentation is done. But what it does is it goes through, we'll walk through all of the legislation that has been passed in the past year and that you all really need to be aware of. I've tried to really highlight the must knows so that when you walk away from this webinar, you feel that you at least have some understanding of what you need to be paying attention to. And then also recent case law. So case law that will sort of guide us looking to what we can expect going into this 2021, where we think the legislature may go, what trends we're seeing, what the courts are, how courts are interpreting certain employment law issues. So we'll go through all of that. So let me pull up for you. Okay, can everybody see that okay? All right, great. Okay, so we'll go through this, and if you have any questions, I know there's that chat box. Feel free to chat, or we can, sort of address if you at the end. There'll be time if you have any questions. So we'll just take it away. Okay, so 2020 didn't disappoint in terms of making everybody crazy and having all sorts of different changes. That is true for the legislature and for the laws. COVID-19, we saw this year was really a different world for the legislature. They had to recess several months due to COVID-19. They actually had to shut down the legislature twice. With that, there was shortened timelines for hearing bills. There was also a limited number of bills. So there were only, when we usually do these legislative updates, we have a significant more bills to review and to go over. But the ones, I'll tell you, the 25% of the normal volume that they did, they sure packed a punch. These bills are very cumbersome. They're very, employers are having to pay out significant amounts of money. So they really are impactful, much more than other bills or laws that we've seen in the past. So the governor signed the veto bills up to September 30th of this year. So because the legislature was sort of on the ropes and having to close down for various times, Governor Newsom really tried to pick up the slack. He and the local governments started to issue orders in lieu of the legislature just because of all of the closures that they were experiencing. So when they were out of town, he did issue several executive orders. I'm sure you've heard about them in the news. Many were local governments passed also COVID-19 paid sick leave and other employment ordinances. So that's kind of why we saw all these different regions were having these different requirements, but then we would have these executive orders from governor. So one of the sort of more important ones that was done by the governor was Executive Order N3120, which amended or loosened the WARN Act. If you're not familiar with what the WARN Act is, the WARN Act there's a federal WARN Act, and then there's also a California WARN Act. And in California, the purpose of the WARN Act is if a company is going to be doing a large layoff or a large termination of its employees, then they are required to give 60 days notice so that those employees can try to seek alternative employment or are able to sort of get their ducks in a row before they're actually terminated. But with COVID and with all of the changes, I mean, during that March, April, May timeframe, I was fielding calls nonstop. And I'm sure a lot of you may have experienced it from employers that were just reeling with, what do we do? Do we lay people off? Do we, can we like keep them furloughed? Should we keep them furloughed? All these different questions. And you weren't looking at a 60-day time frame. People were talking about whether or not they could get in within a week, or they needed to let these people go right away because they were bleeding money. So what happened is the governor reacted to that. So he ultimately loosened that California WARN Act 60-day notice requirement if the following three conditions were met. So either the shutdown was caused by unforeseen COVID-19 business circumstances, employer still provides written notice, so you still couldn't get away with not doing written notice, you just didn't have to have 60 days. And the written notice contained specific information about why the layoffs were being done. Another executive order, another important one, was N5120, which was paid sick leave for food sector workers. Now, you all probably remember, and maybe you had to deal with, the CARES Act that was implemented, which applied to employers under 500 employees, where they were required to give 80 additional hours of sick leave for individuals who were suffering either from COVID or their kids were home from school because of COVID. And so everybody would sort of scratch their head and said, okay, well, we have this CARES Act that applies for employers up to 500. What about those big companies? What about those companies that were over 500? Why are they not having those same 80-hour requirement? So Executive Order N5120 was in some respects addressing that, but was limited really only to food sector workers. And so this would apply to all those workers in the food sector up and down the chain for employers that have 500 or more employees, and it required up to 80 hours of supplemental paid sick leave. So the reason why this is important, even if you aren't involved in the food sector worker, and we'll get to, this was actually codified and changed into a law, and made some bridge between paid sick leave for these food sector workers and then other employees that have 500 or more employees. Also, there was the Executive Order N36220, which went into workers' compensation presumption. So you had all these open questions of employees going to work and potentially getting COVID, and then wanting to file a workers' comp claim. And there was this question that would always be hanging out there. Well, okay, well, they have COVID and they have worked, but how can we show one way or the other that they got COVID at work for them to be able to claim workers' compensation? And so there was a rebuttable presumption that came to pass. So the sort of standard that employers were told to review was, if the employee tested positive or was diagnosed with COVID within 14 days of performing work at the employer's direction, then the presumption was that they got it at work. And this doesn't work. They can't make that argument if they happen to be working from home. They have to be actually at the work site. And a licensed physician has to issue the diagnosis and a test confirmed within 30 days. And then it shortens that period for rejection of claims from 90 days to 30 days. And this only applied until July 5th of 2020. But again, this is important, and we'll talk about a little bit later. These sort of sort of executive orders really served as the foundations for these later laws. So that's why it's important to understand. So when you say a rebuttable presumption, the presumption is that they received COVID at work, but it means that you can rebut it. So if you have some information or you have some knowledge that they did not receive it, let's say you knew that they'd been out for 2 weeks for the holidays, and you know that they traveled and saw family members and they couldn't possibly have contracted it during your work hours, then that would be something that you could prove up to show that you shouldn't be on the hook for workers' comp. Okay, so what are these new mandates from Sacramento? Now, this has caused my phone to continue to ring nonstop for the past few months. New Cal OSHA emergency standards. So, and a lot of times employers will kind of hear in the background issues about Cal OSHA and these emergency standards and somehow confuse them or think that they are the same as those additional paid sick hours that were part of either the CARES Act or then of that executive order with food sector workers. And they're limited to 80 hours. And they think, okay, as long as we give 80 hours of sick, we're fine. And they'll sort of hear in the background that there's some additional regulations, but not really take it too seriously. That's a mistake. In November, so at the end of the year, OSHA really Cal OSHA really decided that it wanted to stick its nose into this issue and make sure that it had requirements, additional requirements imposed on employers for how they were handling COVID in the workplace. OSHA always is very prescriptive and very direct, and its rules are very, have large consequences if you don't follow them. So it's always something that you want to make sure that you pay attention to. So in November 19th, there was a new emergency standard that got put in place, and it was approved by the OSHA Standards Board on November 19th. And then quickly thereafter, it became effective on November 30th. So employers had really very, very little time to adjust and to get ready for it. But as of November 30th, 2020, this is the requirement that all employers have to make sure that they follow. And we'll go through the different things that you need to make sure that you know about. It includes the biggest thing really with Cal OSHA is it includes, in addition to whatever 80 hours that you may be required to have, it also now includes a significant paid time off mandate that has no cap. So 80 hours is out the window. You have to continually pay your employees that are out, and they can get out for COVID related reasons multiple times, and you would have to pay them during those times. But we'll go into the more specifics now. So what does this Cal OSHA standard require? These are the highlights. Number one, and most significantly, you need a written COVID-19 prevention program. So what that would include would be the elements. How are you going to address cleaning? How are you going to address communicating exposed cases to your workforce? Just like kind of a playbook that you would have. And if you have your injury and illness protection plan, that's what the IIPP is. This is a requirement over and above whatever injury and illness protection plan you already have in place. So Cal OSHA is requiring you to have your own. We have, as a firm for Fisher Phillips, we put together a packet of all these documents that we're going to go through that are sort of templates for employers, just because, how can you create these things out of the air? So, if anyone has any interest in learning more about that, let me know after the program, and I'm happy to talk with you about these packets that we've put together. So you need a COVID prevention program plan. I have one client now who is going through an OSHA complaint where a former employee actually has said that they weren't complying. And so, exhibit number 1 is going to be able to show that they have in place this COVID prevention program plan and that they're implementing it. So the second thing is you need a notice of a COVID-19 exposures and cases. So when somebody comes to you and they say that they tested positive for COVID. So the turnaround, and this is what freaks a lot of people out, is that you need to make sure that you're on point and that you have notified those that require notification within 1 business day. So in the case of, let's say, one individual comes to you and you're only on notice of one person that has COVID, then you need to speak with that person, give them a notice. Then you need to see if there's anyone else in that person that could have potentially been exposed and notify them. So you need to make sure that you have to be, a lot of times what we recommend is you obviously have these notices ready to go before you get into that situation. And so you have templates drafted up and then you just kind of adjust it as it goes. Many of the notice requirements will overlap with AB 685, which we'll talk about in a couple more slides. But what AB 685 is it's a written requirement. And AB 685 sort of runs in tandem to some degree with this Cal/OSHA standard. There are a lot of different overlaps. But the main difference with AB 685 and with this Cal/OSHA new reg that we're all having to grapple with is that they required written notice. So there's these sort of requirements for what needs to be written. Before with Cal/OSHA, it was just you needed to notify. Now it needs to be written. It can be in an email, it can be in some other form such as that, but it needs to be written. And then you also must notify local public health departments of any outbreaks. So, outbreak, there's usually 2 different kinds of outbreaks. One is if you have 3 known COVID cases within 14 days, or if you have 20, a major outbreak would be 20 within a 30-day period. So also in these Cal regs is a really specific timelines for requiring the exclusion of employees that have COVID or have been exposed. So you as an employer, the minute that you find out that somebody has been tested positive, you need to put on your investigator hat and you need to run around and you need to figure out who potentially would have been exposed. And that would be people who had extended, more than 15 minutes exposure with them and potentially could be exposed. A lot of times we'll have questions. There'll be like you have to look at the work site and whether or not you need to inform them. Work sites typically will be where that person goes. So that's part of your investigation. So let's say that they use the break room, they use the restrooms, they use certain common areas. People who would potentially travel in those different areas you're going to need to look at to see whether or not they were exposed. Now, if that person, if you have multiple buildings and this person only ever goes to these one common areas, they don't go to other parts of your facility, you can limit the work site or the work area to that location where that person is, as opposed to broadening it to the others. But it's just something to know. Now, here's the rub. When you have somebody that is exposed or has COVID, you must contain and maintain their earnings, seniority, and benefits the entire time that they're gone. The recommendation is 14 days. So you can imagine that can be really expensive, especially for smaller companies. So when you have somebody, let's say that they get exposed, they sit next to this person at work, they're out for 14 days, full pay, they come back, they are exposed again, then they get to go out again for that full 14 days at full pay. So you can see that this is a really expensive standard for many employers. There's already been multiple challenges in the courts about how does Cal/OSHA even have the authority to require this from employers? And we'll see how that plays out. But right now, it's something that you need to follow. And if you fail to, or if you refuse to, it can come with some pretty hefty civil penalties. So you want to make sure you comply. So also in the standard, you need to make sure that you have a specific return to work criteria. One of the problems, and sometimes people say, is that they require a negative test before. They'll say you can't come back to work until you have a negative test. You cannot require that under these OSHA standards, and we understand that differs from the CDC guidelines, but that's what Cal OSHA is stating, that you can't require a negative test. Now, for testing, you have to offer free testing during the working hours when there has been a positive case in the workplace. You don't have to mandate it. There was some question in the language whether or not it needed to be mandated, but you need to be able to offer it to them. And during the during working hours doesn't mean that they have to only do it during their scheduled hours, but you need to make sure that you offer it and it's available to them. Additional weekly or twice weekly testing is required once you have an outbreak. And when I say required, I mean that you need to provide it to them. And then major outbreaks is the same. So additional specific requirements related to physical distancing, face coverings, employer provided transportation, and housing and training instruction are also all part of these Cal emergency standards. If you have specific questions about those, I'm happy to answer them. Or else we have, on my law firm, we have changed our, for a while anyway, our cover page of our homepage of our firm's website, just because of this was such a huge deal, COVID and all of the laws surrounding it. We changed it into a whole COVID database of documents and information. So if you ever want to go there, it's just free. You can access it. And there was legal alerts that talked about kind of the new OSHA regs and what everybody needs to make sure that they're doing to try to comply. So moving on from that, we also had AB 1867, which is also a supplemental COVID-19 paid sick leave. So this was, as I said, one of the kind of big hot topics was the supplemental paid sick leave related to COVID. And we talked about the CARES Act and then the executive order for food sector workers. And so AB 1867 was passed, and it was aimed at providing employees with paid sick leave for COVID-related reasons. The 3 areas of coverage for COVID-related paid sick leave. So it codified that existing requirement for 80 hours for food sector workers of employers of over 500. So it just took that executive order from before and made it law. It expanded the benefit to all employers with 500 employees. So expanded not only paid food sector, but now everybody who has employers with 500 plus are having to give this 80 hours. And it also expanded the benefits to cover employers of healthcare providers and emergency responders whose employers opted out of the CARES Act or the FFCRA. So it begs the question, well, what about all those employers that are under 500? So the CARES Act expired, but what this did, AB 1867, was it made it so that sick leave is triggered when a worker can't, okay, so I got ahead of myself a little bit. So sick leave is triggered when a worker cannot work due to a government quarantine or isolation order, a healthcare provider order to quarantine or isolate, or a hiring entity's health concerns related to potential transmission of COVID. So full-time employees receive 80 hours, the part-time and variable schedule employees get a reduced amount. So again, this is all for all of those employers that have 500 or more. The rate of pay for sick pay is the higher of the regular rate from the last pay period or the applicable minimum wage capped at $511 per day. The effective date, so this was a budget trailer bill that had an urgency clause, so it became effective immediately for food sector workers and effective September 19th for the other 2 categories. So again, these are for employers over 500. Workers' compensation presumption. So we have subject of one of Governor Newsom's executive orders during the pandemic, but as we discussed. It's one of the hot issues when the legislature returned. Multiple bills dealt with this subject. Ultimately, the bill that was signed was SB 1159, and that went into effect immediately. So what this law does is it has three parts. It codifies or makes into law that executive order that ran through July 5th, which said a case is presumed to be covered by workers' comp if the infected employee tests positive or is diagnosed within 14 days of their last day worked outside of the home. The physician diagnosis must be confirmed by a test within 30 days. That presumption is rebuttable by evidence, but the claim must be denied within 30 days to be eligible. It extends the above for first responders and healthcare providers so that the executive order provisions bridge beyond that July 5th for those groups. And it creates a new rebuttable presumption for cases occurring on and after July 6th, but only where the employer had an outbreak. So an outbreak then is, as we said, the 4 positives in 13 days if 100 employees or less, or 4% of the employees if over 100, or closure by a public health authorities. Workers' comp carrier reporting requirements added, as well as when an employee tests positive, 3 business days plus a look back reporting period to positive tests back to July 6th. So it just kind of continues that on. All right, now this has also been a big deal for everyone else out there. Senate Bill 1383. So what this did is it expanded California's Family Rights Act. And what that is a law where employees are provided the ability to have protected leave when they are either have the birth of a child, or they're taking care of a family member, or they are have reasons that they themselves need to take time off. It was really originally part of Governor Newsom's budget proposal. It's been a continued debate over the recent years. It was one of the few bills that got through the legislature that didn't have anything to do with COVID, and the employer concerns, especially on the heels of the COVID-19 crisis. So what did it do? Typically, CFRA was only applied, or was only, companies only with 50 or more employees had to worry about CFRA and giving that leave. But now they lowered it, so more and more companies are on the hook. They are now limiting it, so 5 or more employees, and you have to provide it. And they also had a pretty limited definition of who would be a family member that would allow you to take that time off to care for them. So now they've expanded the family members to not only include those that had originally been part of the law, but also now adult children, siblings, grandparents, and grandchildren. So you can see how that would extend the amount of people or reasons that people would need to take off work once you are needing to care for any of those individuals. There's a potential stacking issue with FMLA. And what that means is if you're an employer that is required to provide FMLA leave to your employees with the Family Medical Leave Act, what it could mean is that you could have them sort of work in one after the other, so that the employers could, or the employees could take one leave and then be able to take the next leave afterwards to have an extended leave. A lot of times people will try to, in their handbooks or in their policies, make it that leaves run concurrently so that they can cut down the time so that they ultimately are having better, to make it so that they don't, employees aren't able to take out as extended amount of time, but you can't do that here. There was also, with CFRA, there was a 2 employees at the same employer rule, which meant that, let's say you had a husband and wife who had a baby and they both worked for the same employer. There was a law that said that they couldn't do that. They couldn't string it out where one would had the 12 weeks of leave, that one would have the 12 weeks of leave, and then the other could then take an additional 12 weeks of leave if they were at the same employer. And this new CFRA expansion actually says that's not the case anymore, that indeed they can do that, that two employees that have the same qualifying reason, if they are, even if they work at the same employer, they're both entitled to that full 12 weeks. So they can both then go one after the other and ultimately have 24 weeks rather of time, let's say with a newborn, under this leave. It eliminates highly compensated exemption to reinstatement provisions. So a lot of times when we've been looking at leaves or you've had to deal with leaves, if sometimes people will say if it's one of their highly compensated employees, that they would not have to then reinstate them, that because how can they function the business without these highly compensated individuals, that they would need to replace them. But this eliminates that. So it makes it harder for employers, of course, to in those circumstances where it's the highly compensated employee that's at issue. So kind of hearkening back now to what we had talked about with Cal OSHA, another legislative change is this AB 685. And this is what I was talking about in terms of the COVID reporting obligation. The legislation was introduced following some highly publicized outbreaks where employers were alleged to have not informed their employees that was happening. And it imposes some significant and complex notice requirements that went into effect on January 1, 2021. So this is that assembly bill that I was telling you kind of works in tandem with Cal OSHA. So we already knew that AB 685 was sort of coming down the pike, and then all of a sudden you had Cal OSHA step up and add these additional mainly paid leave requirements. But the two of them overlap a great deal. But AB 685 here's sort of the specifics. So when you have, what triggers a notice under 685? So your employers are required to provide notice within 1 business day when they have received notice of a potential exposure. Notification from a public health official or a medical provider that an employee was exposed to a qualifying individual at work would qualify. Notification from an employee or their emergency contact that they are a qualifying individual would obviously qualify. Notification through the employer's testing protocol that they are a qualifying individual. So in red, this qualifying individual would be somebody who is potentially exposed or has COVID. Notification from a subcontracted employer that a qualifying individual was on the work site. So any of those issues would trigger the notice under AB 685. So here's the definition of a qualifying individual: has a laboratory confirmed case of COVID, has a positive COVID diagnosis from a licensed healthcare provider, has a COVID-related order to isolate from a public health official, or has died from COVID. So if you have notice of any of these qualifying individuals, that's when this gets triggered. Okay, so what do these notices have to look like and who receives them? So you must give notice to employees and any employees of subcontractors. So that's important. And not only subcontractors, but anyone who may have been on the premises that you're aware of. So you must give notice to employees and any employees of subcontractors who are on the premises at the same work site as the qualifying individual that they may have been exposed. Now, work site, like I said, is really fact specific. You want to make sure that you look at your particular work sites and whether or not that employee, the employee or the people who were exposed, where they traveled to determine what your quote unquote work site is. You must give notice to employees and any employees of subcontractors who may have been exposed with information about COVID-19 related benefits they might be entitled to under all California state and local law. And you must notify all employees of the disinfection and safety plan that the employers plan to implement per those CDC guidelines. So that's why that plan that I talked about earlier, you have to have as part of your injury and illness prevention plan related to COVID is really key, because then you can share with them what your disinfection and safety plan is. Under AB 685, you also have to have an outbreak notice. So if a number of cases meets the definition of an outbreak, which would generally be 3 cases, you must notify the local public health agency within 48 hours. And when I say 3 cases within 14 days, or else 20 and 30 days. But you need to notify them within 48 hours of the names of the employees, the number of employees, occupation and work site of the employees, and then the business address and NAICS code of the work site. And you also, if you have the fortune, I guess, of dealing with unions, you also need to make sure that you're cognizant of those responsibilities too. If you need to alert any of your union members of outbreaks, if any of their union members are impacted. Okay, so moving off a little bit of COVID again, is Senate Bill 973, which is a pay data reporting legislation. This was kind of in the vein of trying to make sure that pay equity issues are addressed and that certain populations are well represented and well compensated as they should be in the state. So under the Obama administration, there was a pay data reporting program that then became halted under Trump. And this was a way to say, okay, well, it's halted at the federal level, but we're going to continue at the state level. So employers with 100 or more employees and those who must file an EEO-1, you have to provide pay data to the state. And pay data reports, mark your calendar if you've got 100 or more employees, are going to be due May 31st of this year. And it's going to be for the previous year. You have to include the race, ethnicity, and sex of your employees. It amends the California Equal Pay Act, and it allows the DFEH, or the Department of Fair Employment and Housing, to enforce instead of just the labor commissioner. So it really beefs up what reporting requirements employers with 100 or more must do. So who has to file? So how do you count this 100 employees? So employees located inside and outside of the California are counted when determining whether you have 100. So it's something to keep in mind. I think a lot of employers are hoping that they just only have to count their California employees, but no, you have to count both. It also includes part-timers. So an employer has the requisite number of employees if the employer either employed 100 or more employees in the snapshot period chosen by the employer, or regularly employed 100 or more employees during the reporting year. So the snapshot would be a pay period that you could choose to show sort of a slice in time when you're doing that count of 100 or not. But that you can choose either way of determining 100. So do you have to report both California and non-California employees? Well, the DFEH has 2 options. You can either include employees assigned to California establishments and or working within California, and you may also include other employees. They kind of give you the option. They're like, you can stick with California or you can report all. It's really up to you. These reports must include race, ethnicity, and sex of your employees. There's the job categories, and they give you 10 categories that you can choose from. The number of employees whose earnings fall within the pay bands used, the number of hours worked, the report for each establishment and a consolidated report, much like an EEO-1, and their NAICS code and any clarifying remarks, whether or not that's completely voluntary. But you're allowed to use the EEO-1 as a basis for the report, but you just need to know that this is something that you need to make sure that you have ready come March this year. So it's going to come quick. The information is private until the DLSE or the DFEH use it to file an enforcement action. The reports will be maintained for 10 years. This will be a lot of work, so plan now. We also had Assembly Bill 2992, which was for victims of crime. So this amended the existing law, which was providing job protected time off for employees who were victims of domestic violence, sexual assault, or stalking. So this needs to include a victim of a crime that caused physical injury or that caused mental injury and a threat of physical injury. And then the immediate family member, either a child, parent, spouse of a person who is deceased as the direct result of a crime. Now, before COVID, all I was ever talking about was AB 5. And I don't know if to the extent that everyone remembers even that, it seems like so long ago, but sort of the history of it goes that we have in California for a long time, for 30 years, had a law, a case called Borrello, which had been the standard for who was an independent contractor. For 30 years, the idea of independent contractors, the test was really came down to the level of control that the employer had of the independent contractor. It made it so that a lot more people could be independent contractors because of the way that the test was run. Then lo and behold, we had a case Dynamex that came through, which sort of rocked everybody's world in the employment law world, I should say. And what it said is it changed this 30-year Borrello control test to something that was much more difficult to pass. It was much more difficult for employees to have independent contractors because of the requirements. Under Dynamex, it established what's called the ABC test, which made it so that employees, you couldn't have somebody that was doing the same work as you be an independent contractor. So to put it in, personally, for my firm, for example, we would have contract attorneys. If you would have contract attorneys that were independent contractors, so I'm an attorney, I'm doing attorney work, they're attorneys, they're doing attorney work, but they're under the umbrella of an independent contractor. Under AB 5, or under the ABC test, rather, that's not allowed. And so you can imagine, having independent contractors saves business a great deal of money. They don't have to pay employee benefits. They don't have to do all these other things. So, the sort of reckoning was, well, all right, some of these businesses can't even exist if they can't use this independent contractor model anymore. What are we going to do? And so we had AB 5 and so Dynamex was out there, it was floating around, and everybody thought that this was some silly kind of aberration. This law was never going to get codified because it was going against 30 years of precedence and everything was going to go back to normal. And people who had always been independent contractors now are going to be able to continue to be independent contractors. Well, in last year, when I did this legislative update, we had Governor Newsom had signed AB 5, which actually made that a law. So it changed Dynamex, it changed the ABC test, and now all of a sudden there had these much more stringent requirements on who could be an independent contractor. And I mean, honestly, I had so many calls where, the general consensus was really that there were no independent contractors in California anymore, simply because of how stringent this test was. So there's also there became carve-outs. So there were certain industries or professions that were able to then kind of continue to be under that Borrello test because they had good lobbyists, most likely in Sacramento, that made it so that they were able to get those exemptions. So they were under the old standard, but then other industries weren't. So the question was, okay, now what? So you had, and I'm sure you saw through the ballots and everything else, that you had gig workers and Uber drivers and everyone else. They were not one of those exceptions. They were still under this stringent ABC test. And so now they were all needing to transfer over to be employees. And, I'm sure you heard the backlash. There was most of the workers for Uber or drivers didn't want to be employees because it limited their ability to have sort of their own thing happening when they would be working. So there's been a big fight. So it hasn't gone away. Lobbyists are trying to challenge this law up and down the state of California. So AB 2257 was sort of a follow-up to this whole drama. So the debate continues regarding additional exemptions. So many different industries are trying to make it so that they're still under that old test as opposed to the new test. There was the same dynamic as last year. Assemblyman Gonzalez was in control of what was passed, and there were several dozen Republican bills that weren't even heard. This year, which went into effect, AB 2257, immediately on 9/4/2020, there's now 109 of those exemptions from the ABC test, or categories or different professions that now get to go under that less stringent standard. There's key changes to the business-to-business exemption. So a business-to-business exemption would be, for example, if you run a company and then you hire a valet company to park your cars. The two of you are doing different things. You don't have any interaction. So that was sort of thought of as like a business-to-business exemption. You can provide services to the client as long as doing so under the name of the business service provider, and the business regularly contracts with others. And you merely have to show that the business service provider can contract with others and can maintain a clientele of their own. It looks funny or it looks fishy if you're their only client, right? You want to show, if you truly are two separate organizations, that they have other clients and they do other things outside of helping you. There's key changes to the referral agency and service provider exemption. So there's a non-exclusive list of industries the exemption can apply to, but now specifically excludes janitorial, delivery, courier, transportation, trucking, agricultural, retail, logging. All of those different categories now kind of got wrapped into that exemption. So they're able to benefit from the earlier, less stringent test. Then we also, AB 3075 and the Gonzalez wage theft legislation. So this one is really kind of aimed at those shady characters that will get sued or have some issues, and they'll close down and they'll reopen under a different name, and they'll just try to scam people out of judgments and liability for wage claims. So, Gonzalez was like, enough, we're going to do AB 3075. And it just requires that businesses at the time that they incorporate, that they have to say that there's no officer or director has an outstanding final judgment to make sure that they don't get to have all these fly-by-night companies out there that are taking people for a ride. It establishes successor liability for a final judgment for wages and penalties. So you can't escape your bad debts, essentially. The successor uses substantially the same facilities or substantially the same workforce to offer substantially the same services. A lot of use of the word substantially. The successor has substantially the same owners or managers that control labor relations. Employs as a managing agent anyone who directly controlled the wages, hours, or working conditions of the predecessor, and operates a business in the same industry, and then the business owner has a partner, officer, or director who's an immediate family member. So you can just see that it's just trying to root out corruption and make it so that people aren't able to just kind of get out of the debts that they're owed. Then we also have AB 1947, retaliation claims. Hard to believe this was only 25% of the normal bills, but it was. So AB 1947 with retaliation claims. So it extends the deadline for filing a retaliation claim. It had been 6 months, so now they have up to a year. And it authorizes one-sided plaintiff-only attorney's fees, which isn't good news for employers necessarily, for Labor Code 1102.5, which are essentially whistleblower claims. It increases the stakes for these claims, makes them much more expensive to settle, and makes them more likely to be filed in court, which isn't great news for the employers. We saw similar extensions with the DFEH. Last year, it extended beyond the 1 year statute of limitations that had been typical to 3 years. So it's, I think that these laws are becoming more and more forgiving to employees. I mean, California is one of the most employee-friendly states, which I'm sure any employer could tell you here in California. But that's what we're dealing with. AB 1963 expanded who is a mandated reporter, and specifically they focused on HR employees and those who supervise minors. So those are the two groups. It requires employers to provide those employees who are mandated reporters with training on such duties, and maybe online training from the Department of Social Services. So, most likely for all of you, the key one is the human resource employee. So as a mandated reporter, the employee designated by the employer to accept complaints under FEHA, you would be a mandated reporter. And it makes sense, right? People are coming to you raw with complaints about potential abuse or claims that they may have under the FEHA, which is the Fair Employment and Housing Act, let's say for discrimination, retaliation, harassment, any of those types of issues. And so you all being as human resource employees, the kind of the eyes and ears of the company who are really on the front lines getting these complaints. If you suspect something that is off and needs to be reported, they're wanting to make sure that you're included in this group. Only those who work for FEHA covered businesses, which would be those who have 5 or more employees, are on the hook for that, but that's who would be here. Also, supervisors of minors, of course, this has always been true typically for teachers or for others, but those whose duties require direct contact with and supervision of minors in the workplace. So this extends past teachers in schools, but if you have a business where you're working with minors and others have direct contact with or supervising them, then this expands their need to be mandated reporters. Is a mandated reporter of sexual abuse only? No, only those who work for FEHA covered businesses, again, 5 or more. Okay, arbitration. Arbitration has been another hot topic under employment law. And the reason being is because, as I counsel all different sizes and different types of businesses, and in California, I'm sure as you're aware, class actions and large litigation is kind of the thing. Employers love the splashy class actions. It gets them more, the plaintiffs' counsel loves it because it gets them more money, and employees like to feel like they're doing justice. So what we counsel employers a lot on is having their employees sign arbitration agreements. So, the reason being most likely is because with arbitration agreements, you can make it so that they agree to not file class actions. And if they have any issue with their employer and an employee files a lawsuit, that they can only bring claims on behalf of themselves and not as a class. So here is Senate Bill 1384 with arbitration. An employee who's unable to have their claim adjudicated by the Department of Labor because of an order to compel arbitration can request that the Labor Commissioner represent them in arbitration. A petition to compel arbitration of a claim pending under either Labor Code 98, 98.1 or 98.2 must be served on the Department of Labor. If requested by the employee, the Labor Commissioner can represent the employee in proceedings to determine the enforceability of the arbitration agreement. And the reason being because arbitration agreements are usually one of the first documents that gets passed over if somebody makes a claim and you say, okay, well, you agreed to arbitration, here you go, you signed this when you first started with us. And so this is just to allow some further representation of employees if that actually occurs. All right, and then kind of continuing on the vein of inclusiveness and making sure that workplaces are open to all, AB 979 made it so that is mandating a corporate board diversity. So it's a follow-up to prior legislation regarding female board members. But under AB 979, by the end of 2021, a publicly held corporation with principal offices in California must have a minimum of one director from an underrepresented community on its board. What's that mean? What's an underrepresented community? That would mean an individual who self-identifies as Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, or Alaska Native, or who self-identifies as LGBT. By the end of 22, these requirements are going to increase. So if you have 9 or more directors, you need at least 3 directors from the underrepresented community. And then so on. If 9 directors, 5 to 9, then you have to have at least 2. And if fewer, then at least 1 director. So litigation's already been filed challenging this law, but just so that you know it's out there. But it is only for publicly held companies. So if you're not publicly held, this wouldn't apply to you. Another biggie, Proposition 24, which is essentially the California Privacy Rights Act. This has sort of been in conversation for a while now. And so what it really, if you're not familiar with that, but it requires certain companies to provide notice regarding private information that's out into the public domain or that's being collected. So effective January 1, 2023, with some provisions having a look back period of 12 months, it amends and expands the California Consumer Privacy Act, changes to which the businesses are required to comply with the CCPA, and extends until January 1st of 2023, the limited exemption for data from employee job applicants and in the B2B context, which is the business to business context. So under Prop 24, there's data minimization. So you can't retain data for longer than necessary for disclosed purposes. You have new requirements for a business's relationships with vendor service providers. There's a new right of consumers to request correction of inaccurate personal information. And then it also establishes the California Privacy Protection Act. So it shows that they're really taking it seriously and that they're establishing their own agency to take care of these issues or to address the issues. Okay, so that was kind of a whirlwind. The next section is sort of the case laws update. So it's the information that is sort of the hot laws that are out there right now and the changes that we've seen and what we think the trends are. Kathleen, if we want, we could take like a 5-minute break. Or would you rather continue on? I'm happy to do either.
Do you want to answer? There's a couple questions in the chat. We can, do you want to answer those real quick?
Yeah, absolutely.
Okay. So the first question is N362-20 for employees or employers of all sizes?
Let me go back real quick. Oops, sorry. Just so I can make sure. I'm not sure how to. So we're all on the same page. Let me pull up. Which one were you discussing?
N362-20.
Okay, the workers' compensation presumption. So yes, this was. The workers' compensation presumption. Yes, that was.
Okay. Next question: are these forms available anywhere to download?
Yeah. So as I shared, my firm has put together. So with the Cal OSHA notice and everything else, what we have to put together is a packet. It's kind of turnkey. So what it is it has every notice ready to go that's in a template format. And then we have a workers illness and prevention plan for COVID-19 already put together. Also part of the requirement is to train your employees. So we have a PowerPoint presentation ready to go. So there's a resource for us that you could reach out to our firm. I'm also sure that on Cal Chamber, you may be able to find some other information or on any of the labor commissioner websites. But, if you want to reach out to me, I'm happy to kind of link you with that and kind of let you know. I can share with you what we have and see if that might be of interest to you.
Okay. Next question. How do you tell people about possible exposures without breaching the HIPAA confidentiality laws?
So you don't need to share. You try your best to keep that information confidential as to who it is that has that exposure to the best that you can. So, I understand with the HIPAA and all those other issues, but here you're really needing to make sure that you comply with these Cal OSHA where within a day you're making it. So you could just, say it generally that we believe that there was an employee that you came in contact with in the last 24 hours or et cetera, or, you're in the same work site, but do your best to make sure that you maintain that confidentiality of that employee.
Okay, perfect. Any other questions? You can go ahead and unmute yourself real quickly. We'll give it a minute and then we'll take a 5-minute break.
Okay.
All right, no other questions. We'll go ahead and take a 5-minute break. We'll resume here at 12:40.
Okay.
Thank you.
Thank you very much.
Patrice, as soon as you're back, we'll get started with the second portion.
Okay, I'm back. Kathy, I'm sorry, my screen's frozen for a second. Let me try to.
No worries. We'll get it going in just a second. You know what? We do have another question.
Sure.
How are we to allow an employee to return out to work after testing positive to COVID-19 if we cannot require a negative test? What are our alternative options?
Yeah, that's a great question. So there's within the Cal OSHA regs there are certain requirements that you can have. So without requiring testing, you can make it so that, let's say, I think it's 10 days from the date of their last positive test, you can allow them to return, or there's certain criteria that you can make sure that you have in order for them to come back. So that's the requirement, but they don't want to go so far as to make it so that you're mandated to have the test. If you want to email me, I'm happy to kind of give you the specifics on what's mandated. Sorry, I'm having trouble, some technical difficulties. Let me just get to this slide that I want to start with. Okay, can everybody see that okay?
Yeah, we can see it.
Okay, great. Okay, so so this is a little bit of the sort of dry portion maybe of this discussion, but what it is it's very important, because what it shows is all of the trends and the new cases and where the courts are looking. So when you're really trying to be proactive with your business in terms of how you're protecting your employees, how you're protecting your business, these are the issues that are being debated out there just in this last year. So they really give us some key insight, and it helps you kind of get ahead of any curve to make sure that you're ready. So the case is Sanchez versus Martinez. And in this case, what you had was we had some farm workers who were arguing about rest breaks. Anyone here who has done much work in California knows that meal and rest breaks are the really hot topics. Employees are required for their meal breaks, are required to clock out before the start of their 5th hour. And rest breaks, they're entitled to 2 15 or 10-minute breaks within the time period, the required time periods. But what you have then is all this litigation. I'm right in the middle of a nasty, nasty class action that goes all up and down California simply on meal and rest breaks. So what employers are getting hit not only on not allowing or not providing the opportunity for their employees to take rest breaks, they're getting hit. They get hit with that, but then they get hit with penalties. And I mean, the numbers get astronomical really quickly. Wage and hour in California is such a hot topic now, and plaintiffs' attorneys love it, mainly because if you have clock in and clock out records, or you don't have clock in, or worse, you don't have clock in, clock out records, that can easily become fodder for a class action or some larger claims. So here in Sanchez versus Martinez, you had some farm workers who said, okay, we weren't getting our rest breaks. And so they, this is actually a good case for employers. They said, so not only since we didn't get our rest breaks, we want to make sure that we get paid not only for that time that we should have been paid, that when we didn't get our rest breaks. And then also we want a penalty on top of that. So the good news for employers is that the court said no. They said no, that for you are able to get either compensated for your rest breaks, or you can get an additional hour of pay as compensation, but you can't get both. It was just the way that the court was interpreting these labor laws, which are always in flux in how they're being interpreted. But this is good for employers, meaning that let's say you fail to give rest breaks, you just need to pay them for that time. You don't then also have to pay a penalty. Kim v. Raines was another case that was really important this year in 2020. I don't know how much of you all are familiar with PAGA or what PAGA even is, but it's the Private Attorney General's Act. And what PAGA does, and this sort of harkens back to what I was talking about with the class actions or the arbitration agreements, where employers are we're advising employers to have their employees sign arbitration agreements, simply because then they can make it so that they have to settle their claims individually in arbitration and they can't bring class actions. Well, the plaintiff's attorneys got sick of this. They started to get upset that now all these employers were wise to these class actions and were having all their employees sign these arbitration agreements. And so they tried to figure out a way to work around that. So what they ended up doing is they ended up finding this old law that was from 2004. It's called the Private Attorney General's Act. And essentially what it is it's a law that says that employees can bring claims on behalf of the private attorney general for labor code violations of their employee. And so what that's morphed into is they can bring it on behalf of them as an aggrieved employee, and then they can bring it on behalf of all others that they think suffered labor code violations. So it sounds a whole lot like a class action. And it's kind of a new phenomenon. Courts really aren't knowing how to deal with this. In class actions have very strict requirements. You had to be able to show how you could certify a class. There were all these requirements on what information you would pass between the company or the employer and plaintiffs or plaintiffs counsel, identification of who would be in the class, how to contact them, etc. It was much more sort of clear as to how those rules were going to play out. With PAGA, or the Private Attorney General's Act, it's kind of the Wild West. And right now, employee counsel or plaintiffs counsel are able to really have, the stores open to them. They're able to get whatever contact information. They're able to get all sorts of information under just general discovery about every person that ever worked for you and their contact information, forevermore kind of thing. And so you can imagine that that's a super scary thing. And also if you have somebody who has a labor code violation, let's say they didn't get their meal breaks, even if they didn't have other labor code violations, that was their only labor code violation, they can bring a PAGA claim on behalf of others for other labor code violations, even though they themselves didn't suffer it. So PAGA has become the flavor of the month for plaintiffs' counsel. There's been a big fight trying to say that, if somebody brings a claim in arbitration, there's been a big push to try to make it so that the PAGA claims would also go into arbitration. But the courts have pretty resoundingly said no. They say because the private attorney general is really the person that is being brought on behalf of, and so the private attorney general isn't a party here and can't then have his claims dismissed in an arbitration. So what happens in practice is let's say you as an employer receive a PAGA claim and you receive just a general discrimination retaliation claim, and you have an arbitration agreement. What that means is then you could potentially go to arbitration on all the claims but PAGA. PAGA just sort of hangs out in the wind until you resolve whatever you need to in arbitration. And then after the arbitration, then the PAGA claim gets kind of revived, and then you have to deal with that. And so what Kim V. Raines in this case was saying is you had this plaintiff who filed an action. They filed a civil claim and then also a PAGA action. She couldn't bring her class action because she had an arbitration agreement, so that went away. She settled all of her claims individually in arbitration, and then they were going to come back to PAGA. And in order to have a PAGA action, you have to quote unquote be an aggrieved employee, meaning that you suffered some violation. So these very creative attorneys argued that because she had settled her claims on her own, she was no longer aggrieved. And so how could she be a representative for this PAGA collective action outside of the arbitration? And actually, before this came down, I had an awesome argument that I was really excited about in a case where we thought we could even get it dismissed because we were trying to say that she was no longer aggrieved. And pretty much 2 weeks before we were going to make that argument, this case came down. And so it's really taken that ability to make that argument that employees who dismiss their individual claims, the finding by the court basically was they are still an aggrieved employee under PAGA, even though they themselves have settled their own claims. So it's unfortunately, that's sort of been the not a good result case for employers. The next case is Walker v. Fred Meyer, Inc. And this is a case related to fair employment consumer reports and checking people's backgrounds and their credit scores. So you had a Walker who was a plaintiff who applied to a grocery store, Fred Meyer, Inc., and was trying to get a job. And as part of his application, he had to fill out 2 different consumer credit reports authorizations to say, okay, you can check my background and get my credit report. And so they went through the hiring process and he was hired. And then he received a pre-adverse employment action notice. So they got his credit reports back and they didn't like what they saw. And so they put him on notice like, okay, we have some concerns about you. And it said that it gave him a copy of his consumer report. And then it said, okay, if you have any issues, you can contact the reporting agency and see if you can't clear anything up. And so you can imagine that didn't sit too well with him. And so he, and then they came back to him after that and they said, okay, you know what, we don't want you to work for us. So he filed a class action and he claims that by doing that, by terminating him, they willfully violated the Fair Credit and Reporting Act. He said that the documents that he had to sign were all full of all sorts of legalese that he couldn't understand and extra information. And so how could he have, he was duped into signing this document basically. And then they also said that he failed to, that they should have allowed him to talk to them as opposed to just the consumer reporting agency, that he should have had the opportunity to go to them and explain, the issues on his disclosure. So that was really the main issues that were presented in the case. So the court kind of had somewhat of a split decision for the employer and the employee. Essentially, what the court said was that the disclosure was a bit cumbersome, that if you are going to be seeking somebody's information, the disclosure requirements and what you're going to be saying that you're going to be getting from them has to be super clear. It has to have clear language. It has to not consist of all this extraneous information that is going to potentially confuse them. So it really, if you are running reports, consumer reports, make sure that it's not just all legalese, confusing language that could potentially come to bite you at the end. You need to make sure that it's as concise and clear as it can be. But then it also said, the court, that he didn't have to go to Fred Meyer, Inc. to clear up his, that that's not a requirement, that they're able to terminate him without him coming and discussing the issue. We see sort of similar issues. I don't know if you all have experienced with criminal background checks, where the requirements are that if something comes back and somebody has a really bad, shows that they committed all these terrible crimes or whatever it is, that they're provided a copy of that, and then they have to have you have to give them an opportunity to speak to you and to kind of clear up whatever issues there are. Here, they were saying with the fair reporting issue that no, they didn't need to come to the employer, that it was fine to refer them to the consumer reporting agency. Okay, then we have Anthony versus Trax International. This was kind of an interesting case. So Trax terminated Anthony from her position as a technical writer. And she was terminated, and then she brought suit against the company saying, no, I was wrongfully terminated. I have a disability. You failed to engage in the interactive process with me. And then lo and behold, throughout the litigation, I think at a deposition, it was uncovered that, wait a second, you didn't even have the basic qualifications to do this position in the first place. And so the question was, like, do they get a get out of jail free card necessarily because they found this information that, wait a second, you can't really make a claim to say you were wrongfully terminated because you shouldn't have ever been there in the first place. And they were looking at this question under the Americans with Disability Act. And so the court found that they were able to offer what's called this after acquired evidence, or evidence that's found kind of in the course of litigation. And they were able to demonstrate that she wasn't a qualified individual under the ADA, and they were able to use that for their defense. So, just keep in mind that, that's not always the case. Like, for example, you wouldn't be able to use after acquired evidence with the ADEA or the Age Discrimination Employment Act, but the ADA allows those protections. So that's just a takeaway there. It was just sort of an interesting case. Then we have Colucci versus T-Mobile. And this is a kind of cautionary tale for anyone who has sort of managers on the ground that are working directly with employees. So what happened here in Colucci versus T-Mobile is you had this employee who came to his manager and said, and he was worked for T-Mobile, and they were going to put him in one of those kiosks in the mall. And the employee said, no, I have anxiety with crowds. Like, there's no way that I can be working in a mall location. And so his manager, his district manager, made fun of him. Basically said, that's the lamest excuse I've ever heard. Like, I can't believe this guy. What does he mean he can't be in a mall? And really dismissed the disability that this employee was sharing. And then down the road, you had additional employees that were making fun of this employee because he couldn't do it, and he was feeling harassed at work. So he filed a harassment claim stating that he felt that he was being mistreated at work. And then the same manager, the one that sort of laughed off his ailments in the beginning, was then tasked with trying to investigate and trying to hunt down if what had actually occurred. And he sat on it. He didn't do anything. And then the employee that was feeling like they were being harassed continued to make complaints and called T-Mobile's integrity line to notify the company that nothing had been done for his complaint. And he complained to his district manager about their failure to look into his complaints about defamation and mistreatment. And then guess what? That same manager fired him. And so he brought suit and said that he had been mistreated. He filed a complaint alleging a cause for retaliation in violation of the Fair Employment and Housing Act stemming from his termination by the district manager. And the jury awarded him a handsome sum. And so you need to make sure that when you have your managers there, this was kind of a perfect storm of bad facts for T-Mobile. And one of the questions that was considered was whether or not this sort of lower level manager that was kind of on the ground with this guy, if he could bind the company, if he was high enough on the food chain to have his decisions really bind T-Mobile, or was he just sort of a rogue actor that they could kind of explain away? He was kind of a low level. And the court said no, that the facts show that he was high enough on the food chain that he bound the company. And so T-Mobile got hit for a big number. So you just need to make sure that, when you are managing or you have employees that are in that kind of lower managerial level, that they're doing what they need to do. They're needing to take complaints of harassment, of medical disabilities, of everything else very seriously, and not being dismissive of them. And if they do get a complaint and the investigation is promptly done, and that managers not only understand the importance of that, but they understand how to do it. It'll save you a lot of time and maybe a lot of money if you do that. So this kind of just goes through that. Another case is McPherson, which is versus EF Intercultural Foundation. This one's important because it addresses what has become sort of more and more popular with companies is an unlimited vacation policy. And if any of you have had employees that, if you haven't, let's say, been very good about tracking vacation, or if you don't have a cap on vacation accrual going year to year, then you sometimes have employees that, they give you their final, okay, my last day is going to be this week, and you're having to pay them out months of vacation because either it hasn't been tracked or it hasn't just been recorded that they'd taken the time off, like all of that kind of information. So that can be a lot. So employers get really hit with these big, at the time of termination, you need to provide them with all their unused vacation time, and that can be really costly. So employers have tried to sort of to curb that. There's different accrual methods that people will use, or they'll set a cap. There's no use it or lose it in California. So, vacation can really mount up, but you can set a cap up to a certain limit, which is okay. So some people do that, but other employers say, all right, well, you know what, we're going to have unlimited vacation. And with unlimited vacation, which while it sounds amazing, makes it so that when you leave, though, you're not having to be paid for the vacation like you would if you actually had an accrual bank or you had certain days that you had accrued for vacation. So it's become kind of a popular thing. So here in McPherson versus EF Intercultural Foundation, you had a vacation policy that applied to hourly employees, but it didn't apply to 3 exempt managers. So the managers were verbally told that they could take time off whenever they wanted, and that they essentially had a unlimited vacation. So when it came time for these managers to leave, and they weren't being paid the accrued unused vacation time that they thought that they were entitled to. So the question looked at unlimited vacation policies and if they were okay. So these employers brought suit alleging the violation and seeking waiting time penalties. Waiting time penalties would be assessed if it went beyond. So let's say you're not paid the amount of wages that you feel that you're owed. Every day after that you don't receive that money, that you're entitled to that same amount up to 30 days. So they're trying to claim waiting time penalties. They argue that they had an unlimited vacation policy and that they weren't entitled to any payout. So when they started to look at it, they looked at, okay, are these vacation policies even okay? And the court really did just sort of fact-intensive analysis of these particular facts. But they said, you can have unlimited vacation policies, that under the labor code, that's okay, but not here. And they made some distinctions here between these people's unlimited vacation policies and how it's supposed to be. that they didn't, because they didn't have a formal written unlimited vacation policy, and they didn't inform the plaintiffs that they were entitled to unlimited vacation, that they didn't actually offer unlimited vacation. And the court held that the policy had an implied limit of 2 to 4 weeks per year, and that the exempt managers generally could not and did not take more than this amount. So it awarded the exempt managers with the damages of that lost vacation, but they didn't penalize the employer. They didn't make them pay those additional waiting time penalties because they thought they had a good faith basis for making that distinction. So yeah, at least they got that. But there's some considerations you want to make sure that you're thinking about if you are using an unlimited vacation policy. You want to make sure that it's really clear, it's in writing, and applies, follows closely Labor Code Section 227.3. Another one, Omen versus Delta Airlines, Inc. So this was a flight attendants brought a class action against Delta Airlines, saying that there were various wage and hour violations. Specifically, they alleged that Delta failed to pay its flight attendants in accordance with the state's minimum wage laws. And so they looked at different code sections to see if an out-of-state employer would have to pay for somebody who's only in the state just for little bits of time, like when they would land, before they would take off. And so they were really trying to study, when does California law attach, and when are they required to comply? You know, so many employers want to avoid as best they can having to pay or follow a California law, simply because, you know, by far and away, it's the most onerous and the most employee friendly than all of the other states. So, you know, whenever they can avoid California law, they do. Oops. So the result here in this case was no, an employee is not entitled to protection under those labor codes unless California is the principal place that that employee works. So just touching down is not enough. The court relied on a case called Ward, which held that the principal place of the work test is satisfied if, number one, an employee works primarily or majority of the time in California, or does not spend the majority of his or her or their time in any one state, but California serves as their base of interest of operations. So it's just an interesting point. If you have employers or employees that are just sort of doing very minimal work in other states, you want to really be aware of that, which labor codes will apply to them based upon their work and where they are located when they do the work. Oops, excuse me. So Frelkin versus Apple was another case that came down this year. This was employees brought a wage and hour class action against Apple, seeking compensation for time spent waiting for and undergoing exit searches pursuant to Apple's package and bag search policy. We see these a lot. And again, with these wage and hour class actions, plaintiffs' counsel just eat this stuff up. But let's say if you have, this is where they're trying to say that should be compensable time, right? They're going in, they're coming in, they're going out, they're being searched. That's taking time away from their travel. And so for those times that they're having to undergo that search, that they should be compensated. The California Supreme Court held that time spent by employees waiting for and undergoing security checks of bags and other personal items is compensable time under California law, even when the policy only applies to employees who choose to bring personal items to work. I've seen this also, let's say, in food packing companies where employees have to get on certain garments before they go and they package food. And if they do that while they're not clocked in, then that could be time that they should be compensated for. And while that kind of seems a little bit, gosh, petty, when you look at this, let's say over, many years, so many employees, and, a minute or two of time here and there, it can really add up. And so, you want to make sure that if you have your employees with uniforms, that you aren't requiring them to put them on, off the clock. I mean, they can come dressed in them, that's fine, but to spend some of their time once they get to the location to put it on. So you want to make sure that you're just really careful of those like de minimis amounts of time. Then we had Herrera versus Duez. We had another case that was pretty similar to this last year, but this was an employees brought a class action against their former employer, alleging that they failed to pay employees reporting time pay for call-in shifts. In this case, an employee was scheduled for a call-in shift, must make herself available to work during the shift, then call her manager 30 minutes to an hour before the shift. Or if she works a shift immediately before the call-in shift, she has to contact her manager at the end of the shift. At that time, the manager tells the employee whether she'll be required to work during the call-in, and if the employee does not work, they don't pay him. So does that employee have to physically present himself or herself at the workplace in order to report to work, and thereby qualify for reporting time? We've seen this issue a lot, and especially now with COVID and everything else, there's a lot more sort of remote communications. And so the issue is, do they get the credit for that? And the result is yes, that, that under this wage order, that a requirement that they call their managers is reporting to work. And, you really have to think about it too, about the control issue. Are they able to really freely go about their business, or not really, if they're have these requirements to be calling in and checking in and seeing if they have to come to work. So they have to be paid for their reporting time pay. Oliver versus Konica Minolta Business Solutions. So this involves, if you ever have any employees of yours that are driving their own personal vehicles to work. So you had some service technicians here who needed to drive their personal cars with all their tools and their parts to the different customer sites. So they weren't actually going to the work location and then to the sites, they would go directly to the sites. They filed a wage and hour class action against their employer, saying that the time they spent commuting to their first work location and commuting home, they thought that they should be paid wages for that time. And then they also wanted to be reimbursed for their mileage when they were doing those commutes. And so the question was, were they legally obligated to pay them for driving their personal vehicles to and from the work site, from their homes? And the court held that that there's a genuine dispute of material fact, precluding summary judgment. All that really means in fancy terms is that they said that there wasn't, that they could dismiss the case based on there was a genuine dispute of, they could not, dismiss the case because there was a genuine dispute of material fact, that they couldn't just get rid of the case altogether. But the court did say that if carrying tools during the commute was optional, then a service technician was not subject to that control, meaning then that they should not be paid. Even if a service technician was required to carry tools and parts, they could not be subject to the control during the commute if the service technician was able to use the time effectively for their own purpose. So they could stop and do errands, or they could do other things. If a service technician was required during the commute to carry a volume of tools and parts that did not allow the service technician to use the time effectively for their own purposes, then they would be subject to the control. So the court, even though they really didn't make a ruling here, they gave us some guidance which said what it's going to come down to, if you're going to have to pay them for that time or not, is did you have control? It's kind of like that prior case about the calling in and reporting time. If that employee really has, they're under your orders, really, that they have to call within so much time, they're not free to go about their own business and go have lunch or meet their friends or do whatever they would do on their own, that they're having to follow requirements from you, then they're really not free and they are under your control and they should be paid for that time. Same is true here. If they're able to drive their own car from their own home and they can stop off and get lunch and they can pick up some stuff for their family along the way, then that you would argue that they don't have control, so you wouldn't have to pay the time. But if that's not the case, then you would have to pay them for their time. So that was a lot of information pretty quickly. If you want to, my law firm, like I said, we have a lot of resources on our website. And there, if you go to the Fisher Phillips website, there's a little thing with a pencil that says subscribe. And you can click on that and you'll just get free updates on all the new laws as they kind of come. We are very, we write a lot. We have a lot of updates all the time. And so if you do that, you just will get sort of new alerts as to new changes in the law that you might need to be aware of. So that's it. And if if you have any questions, I'm more than happy to answer them.
You can go ahead and unmute yourself if you have a question. Patrice, thank you so much for such a fantastic workshop. So much information.
I know. It's a lot.
This is Kathleen McNary here, and thank you so much, Patrice. Of course, it's so good to see you again, and just am so appreciative of your work on this. And I'm not going to pretend I understand much of any of it, but I learned a little. And I also wanted to, since we are perfect timing here, have Human, who's also in the call. And he is the president owner of the company PassPoint, which can also help businesses, especially small businesses, and protect them from lawsuits as well. So knowing what the law is and finding ways to protect yourself are two important ways that you can find the help today. So if we can, Kathy, I don't know if you can do it. Go ahead and let Human speak, or it looks like he's there. Yeah.
Yeah. Awesome.
Take it away.
Thank you. Yeah, I'll just take a couple minutes. I know we're over time. Obviously, we spent a lot of time going over all these new laws and rules for businesses. And I think PassPoint, we've been working with the chamber now for a few months, helping businesses kind of navigate a lot of this COVID compliance. And I won't go through all the rules and stuff, but I think what's important to know is COVID compliance obviously is time consuming if you're doing it properly, and it's costly if you're not, right? So obviously we have citations and Cal OSHA shutdowns. AB 685 gives expansive authority for Cal OSHA to shut down your business if there's an imminent threat. But not only that, there's the productivity loss of sick employees, right? Obviously, absenteeism is one thing, but then there's the investigation time that it takes to contact trace, organize, report the data and all that. And if you're not doing investigations, obviously then you're opening yourself up to legal liabilities, workers' compensation claims, and a whole bunch of other stuff. And really what PassPoint does is it simplifies that COVID compliance. So we basically use technology to help businesses become more compliant. So we automate the daily symptom screening for employees so that we can stop symptoms from entering your workplace. And then that way we stop infections from spreading. Because we know when employees step on site, we also now know the contact tracing. So we can instantly create contact tracing reports that allow you to go back into time, right? So when AB 685, you have to go 2 days prior to the specimen being collected for your COVID positive test. That might be a week ago. We can go back into time and pull that full report for you and then help you investigate a lot quicker. Because we know which employees were on site together, we also have their emails. We're able to notify you of and notify your employees as necessary through AB 685. Our system has pre-made letters that are AB 685 compliant that you can send out, you can upload your own, and then it ultimately allows you to get back to those employees within that 24-hour turnaround time. And then it's available, our whole system is available in both English and in Spanish. So again, part of those notifications are you have to give them in the language that's spoken by a majority. So sometimes that is a Spanish speaking workforce. And our whole system is online, right? So there's no app downloads, there's no new hardware needed. All your existing laptops and everything work. So it makes it super simple for businesses to get it. We've been working with Carlsbad now for a few months. And we still offer, 14 days to all members, 14 days free just to try it out. And then we also offer $10 off your first month just to get started. Our Pass Point's based out of Carlsbad as well. So as a community service, we offer our service completely free to any business less than 5 employees. And then if you have between 5 and 25 employees, it's just $49 a month. You can get more information or sign up at getpasspoint.com/Carlsbad, or I'll put my email in the chat box as well, and you can reach out to me. But anyway, that's just kind of what I want to talk about, and that's it.
Perfect. Thank you so much, Human. And I was just going to say that too. Can you put your email in the box so people can reach out as well? Okay, Kathy, I'll let you get back in, and thank you so much, Patrice, as well.
Yeah, absolutely. I'm sorry I went over. I guess I got a little carried away. And if you ever want to reach out to me or you have questions, if you want to distribute the slides to the attendees, you can absolutely. It has my contact information on there too.
Awesome. Perfect.
Right. And I will go ahead and email that presentation to all those that attended today, so they can make sure that they get your information. Thank you so much. This was fantastic.
Woohoo! And happy Friday.
Happy Friday. Absolutely.